Darren Findling of the Probate Pro, explaining everything you ever wanted to know about probate administration, when to probate, why you need to probate, and the process relating to probate. Let's get right at it. First question is, do I need to go through probate? Do I need to even go through this process? And the answer lies in a question relating to the assets that are owned by the person that died. If they owned an asset that was in their individual name with no named beneficiary and no joint owner, then the answer is generally yes. That asset must go through the probate process. One of the most common misconceptions relating to assets that go through probate relate to whether there's a will or no will. Whether there's a will or no will doesn't dictate or answer the question of whether you need to go through probate. It is the first part that I just explained relative to how the assets are owned if the decedent died with an asset in their individual name. If there's a will, the will simply identifies who will be appointed personal representative and gives a roadmap for distribution. If there's no will, then Michigan statute dictates how and who should be appointed personal representative, and of course the distribution pattern for purposes of distributing the probate estate. So no, having a will does not avoid probate. There are many techniques that you can use to avoid the probate process. That's for another discussion. If you've got questions, give us a call. Let's talk about the probate administration process from beginning to end. So here's a general timeline of probate. If we start at the far left of this screen, that represents today, and to the far right represents the future. To begin the process, a probate estate is commenced by filing documents with the probate court. That can be done formally through a petition or informally through an application. That gets the process started. As part of that document, you're asking the court to appoint a person as personal representative, and you may be asking the court to identify and determine who the heirs are. Also, you may be asking the court to make a ruling as to whether a will should be admitted to probate. Right at the beginning, we recommend publishing one of the statutory requirements of administering an estate for any unknown creditors. For known creditors, you're going to give them direct notice, but for any unknown creditors, you're going to begin the publication process, which is a 4-month process to give anybody that the decedent may have owed money to notice that the estate is being opened and administered through probate. Now, those unknown creditors may be a credit card company, a medical bill, the neighbor down the street. It may be somebody that you haven't even contemplated, and people often ask, if I'm aware that there are no creditors, do I have to publish? And the answer is yes. It's a statutory requirement to do so. You publish for unknown creditors and you give direct notice to known creditors. When you complete that process, you are ensuring that as personal representative, you have fulfilled your legal obligation for creditors. So if a creditor comes forward later on, they are then statutorily barred if you do so timely and correctly. The goal here, as part of the beginning of this process, is to get a letter of administration, a letter of authority. This is the document that gives you the legal authority to act and to be able to administer the probate assets. That may include selling real estate, gaining access to a bank account, a brokerage account. It can include anything relating to the decedent's financial affairs, handling their assets, things that they own, and their liabilities, things that they owe money to. So the personal representative gets this letter of authority through the probate court. Now there may be restrictions on the letters of authority, restrictions as to the authority that you have as personal representative. In addition, the letter of authority contains restrictions and powers, but a broader understanding of the Michigan statutes, the Estates and Protected Individual Code, as well as the court rules, can guide you in your administration. Now, it's critical that throughout this entire timeline that I'm explaining to you, that you understand that doing so without a lawyer is really risky. There are all sorts of pitfalls that you may fall into to get yourself into trouble. So I strongly urge you to hire a competent, skilled probate litigation and administration counsel to guide you through this probate process. You're welcome to call us at the Probate Pro if you've got questions. The next step, as we identified, is that direct notice to known creditors. So any creditor that you're aware of that has sent a bill, that as you're reviewing the mail, that you're aware of that the decedent may have owed money to, you have to give them a particular type of direct notice through a state court administrative form. This is called a notice to known creditors. In addition, you're giving notice to any of the heirs at law, or if there's a will, to the devisees. Any of the interested parties are entitled to notice, as well as notice to the friend of the court, notice to them about the attorney fees that may be charged, and notice of the duties of the personal representative. This is all part of the noticing phase of the personal representative's responsibilities. As part of their role, you're going to start gathering, as personal representative, the assets, identifying and gathering the assets that the decedent may have owned. Now, as we mentioned, that may be real estate, bank accounts, brokerage accounts, and so on. Now, what you do with those assets are really dependent on the circumstances of that particular probate administration. It may be particular to how the will identifies your responsibilities. What's ultimately going to happen to those assets as you're identifying and gathering them. So in this administration timeline, I'm not going to discuss whether you're going to be selling or liquidating the assets or maintaining the assets, but suffice it to say you have to gather them to identify any asset that was in the decedent's name at the time of death with no named beneficiary and no joint owner. And part of that is to then inventory the assets. Now, in an informal administration, you can simply present to the probate court the inventory for the calculation of the gross inventory fee. In a formal administration or supervised administration, that inventory may be filed. That decision about presenting or filing is really a decision that should be made with your lawyer. The whole purpose of just presenting and not filing an inventory is Michigan allows, in certain circumstances, for the information contained within that inventory to be kept private. So instead of it being for public consumption, for anybody to go to the probate court and view the inventory, just the parties that are involved, the interested parties in the probate estate, would have the right to see and view that inventory. Then, of course, you're administering the estate assets. That may include liquidating accounts, selling real estate, handling a business, winding up other affairs of the decedent. This particular phase of the administration is, again, dependent on the circumstances of that particular probate estate. Then, as we reach the 4-month conclusion of the creditor period and the conclusion of the time frame upon which you've given direct notice to known creditors, you're going to resolve debt. You're going to settle or resolve the debts relating to the estate. Now, Michigan has a very clear and precise statute that identifies if there are insufficient assets to settle and pay all the debts, there is a prioritization of the assets before they are distributed. So, for example, administrative expenses, attorney fees, costs, and so on are paid off the top. Then funeral and burial or interment expenses are then paid next, and so on and so forth, including exemptions and allowances, creditors, and then ultimately you're going to distribute the estate. Now, it's really important before you take that final step of distributing that you have checked off each step, that you have assured yourself as personal representative that you've fulfilled all of your legal responsibilities and duties that are identified under the letters of authority, the Estates and Protected Individual Code, and Michigan Court Rule. Because often it's hard to get the toothpaste back into the toothpaste container. So once you've distributed, if, for example, you forgot to pay the IRS a debt, it's awfully hard to get that money back from family members to then do so. So that final phase of distributing should be done carefully and to be assured that you're distributing according to Michigan law. Finally, at some point, you're going to close the estate. And that really means finalization through the probate court, and closing the file at the probate court. It can be done a variety of ways depending on whether, again, it's an informal administration or formal, supervised or unsupervised. That dictates how you actually close the probate estate itself. And again, this is a general timeline. As you can see just by the terms that I've used here, I'm not going into a lot of specificity because it is typically dependent on the circumstances that relate to that particular probate administration. If you've got further questions about probate, whether you need to probate, how to probate, give us a call at 833-PROBATE or visit us at theprobatepro.com. We're happy to answer any questions that you may have, and we look forward to having that conversation with you.